Hi, I'm Matt Culkin, co-chair of Steptoe's Financial Services Group. Welcome to another edition of Steptoe's Financial Services University. We're pleased to present a series of short, scripted conversations with my colleagues from our firm's various practice groups and offices around the world. Today, we're going to talk about international trade and investment agreements. I'm pleased to be joined by my colleague Christophe Bondy in our London office. Christophe, thanks for joining me.
Hi, Matt. Glad to be here.
So before we jump in, you've had some very interesting positions in government over the course of your career. Maybe if you could, for our audience, please just sort of introduce yourself and tell us a little bit about your practice.
Sure. I've been practicing international dispute resolution for over 20 years, and a good chunk of that was spent at Canada's Trade Law Bureau, where I was senior counsel working as senior counsel on international investment agreements, but also spent many years working in support of negotiation of international trade and investment agreements. And offering advice across government, the government of Canada in that case, on compliance with international trade and investment obligations. I've returned to the private sector in 2015 and am a partner in Steptoe's London office. And my practice continues to focus on these areas, continuing to provide advice to governments on international trade agreements and compliance with them, and also being counsel on international investment disputes in particular.
That's great. Thank you for that. So we're going to talk today about specifically the financial services issues that come up in international trade law. And so for those of us less familiar with this universe, maybe let's just start with who's involved and what role do they play?
Right. Well, international trade does and investment do touch on the financial services area in two main ways. One is through the World Trade Organization, or WTO. Back in 1994, the WTO entered into something called the General Agreement on Trade and Services, which included protections available to international traders in financial services through all the modes of that kind of service delivery. And it's a protection in favor of equal treatment in the sense of most favored nation treatment. If you afford a certain advantage to a foreign financial service provider, in theory under WTO rules, you have to provide that to all foreign financial service providers, and also can provide national treatment, that is anti-discriminatory protections, and market access protections, that is the avoidance of quotas. And the GATS agreement also sets out definitions of financial services in an annex, and definitions of what constitute prudential measures that don't violate the obligations. The trouble with the WTO is that it's still a relatively limited coverage because, in particular in relation to services, it's a positive approach where states only undertake to provide these obligations in relation to specific kinds of businesses, financial services, and that can include reservations. So in light of the limitations of that, many states moved towards addressing financial services in free trade agreements. And you'll see since the 1990s, there have been increasingly elaborate financial services chapters in trade agreements. In the US model, there typically is a standalone financial services chapter. And that gets broken down into at least two kinds of protections. One, the kind of cross-border trade and services protections that one would find under the WTO, somewhat enhanced though, enhanced in the sense that the parties can agree to a broader scope of coverage. They'll have less reservations. They might adopt a negative approach, that is, the agreement covers everything but those particular types of those particular reservations. So the cross-border trade and services part of it is covered, but you also importantly have protection for investment. That is, that you have specific substantive rights, the ability to bring an independent claim if a government adopts vis-a-vis your financial services investment in that country a measure that's discriminatory, that's manifestly arbitrary, that can amount to an expropriation. Now, of course, as in all these agreements, there are exceptions. There are going to be differences between the agreements. And one important thing to remember in relation to these kinds of protections offered for cross-border trade and services is that they don't override local regulation. So if, for example, in a particular jurisdiction, one has to comply with a particular regulatory framework, and of course that's going to happen in financial services, heavily regulated as an industry, that means that one still has to comply with those that regulatory framework as an entrant to the market. That's the fact of regulation is not in and of itself discriminatory unless it's a disguised targeting of the foreign investor. So this is an issue right now in international trade more generally, that we have gotten rid of certain obvious barriers like the tariff barriers that used to exist for many goods. In the context of services, and in particular in financial services, we find that one of the bigger barriers, and one thing that's kind of next generation, is how to get over these regulatory differences.
Well, so let's take that background and let's apply it to a specific example. Let's talk about Brexit. So we know there's negotiations between the UK and the EU, and the potential impact on cross-border financial services trade. So what does it look like the deal, like what might that deal include?
Well, the negotiation between the UK and the EU about their post-Brexit relationship is a unique one in the annals of international trade, because it's probably the first time in history that the parties are negotiating down from a previous deep integration to something that's that EU minus, in effect. And one of the sectors that's been most affected by that has been financial services, which from the UK perspective is obviously a key sector. The UK has in effect been Europe's banking center for the past 45 years, despite the fact that the UK is not a Eurozone country. It's still become the place for trading in Euro-denominated financial instruments. Except that entering into these negotiations, the UK government took the position that it did not want to commit to ongoing kind of dynamic regulatory alignment with the EU. So again, that regulatory point. It did not wish to be subject to the European Court of Justice as a final binding arbiter in case of any dispute, and did not want to commit to things like freedom of movement of peoples between the UK and the EU, which was fundamental to the EU structure. So that meant starting out, the UK and EU were in effect discussing a basic free trade agreement kind of framework, something like what the EU was able to agree to with Canada. Now, when you have two parties that are entering into a free trade agreement, that free trade agreement is a coming together, it's a building of bridges. But when you've already been in a far deeper integration, the moving to a free trade agreement model is a step back. One of the key things that the UK enjoyed as a member of the EU in financial services was passporting. That is the right to say, I am complying with the regulations in my home jurisdiction, which is the UK. And that means, as an EU member state, I can go and I can go branch into all of the other EU member states, offer financial services products, and not have to seek compliance with 27 other domestic regulators, which is obviously a huge advantage. The EU, from the start of these negotiations, have basically signaled that since the UK is unwilling to engage in dynamic ongoing regulatory alignment, it can at best accept falling into an equivalency type regime, and I'll speak of equivalency in a moment. But all this to me it means is that the UK is in effect stepping, even if these negotiations are successful, the UK is stepping into a separate regulatory space, and that's necessarily going to mean that it's going to have barriers.
And let's drill down on that. And I know this is something that you and I have discussed. So you have that general dynamic at play. You've sort of articulated quite clearly. how the UK is approaching it. But what does that mean for financial services suppliers, and what do they do to prepare? And sort of building on that, what about third-party financial services companies that use, and you talked about passporting, but how do they go about planning and preparing if they've always used the UK as their entry point into the continent?
Right. Well, to take the UK-based businesses who've traditionally done a lot of business in the EU, for the first point, I think what I've seen is that businesses in the UK have in effect been preparing for either a no-deal Brexit, which is there's absolutely no framework beyond the WTO for dealings with the EU, or in effect preparing for this FTA style arrangement, free trade agreement style arrangement with the EU, where there will be, for example, no passporting. One of the main implications for that at this point is local establishment, so that people in the insurance business, that was more frequent before, but other financial services operators are looking at transitioning to what would be third-party status vis-a-vis the EU, and so creating local poles of business within the EU state space, which will allow them to continue to carry on business. The issue with those kind of beachheads, one might say, in the EU is that the EU regulator for now is tolerating the use of these poles within the EU as a basis for certain euro-denominated transactions. The question is, what is it going to do over time? And the EU has said that it sees it as a not a viable alternative for itself for its main financial center to be outside of the EU. So it's been taking quite a few steps to try to repatriate that business to various centers like Amsterdam, France, Frankfurt. Those are the kind of three main centers that have been cited. So I think that over time, what you're going to see is a kind of tectonic plate shift of financial services business towards the EU. And it's similar for third-party businesses based in the UK. Using the UK as a kind of jumping off point to the EU, it's no longer going to be possible post-Brexit. And many of those businesses should, if they haven't already done so, be thinking about how do I need to establish within the EU, to what extent do I need to establish to be able to continue providing the kinds of services that I provide within the EU now. I know from having negotiated a trade deal with the EU over a number of years, the answer within the European Union to am I able to do this is often, well, just become an EU company. Just incorporate within the EU, establish and you'll be fine. You can go within the whole system. So that's why there is some criticism of being a bit of a closed system. But that's a situation the UK is going to face. The only caveat to that is this notion of equivalence. The EU has set up a regime for the habilitation of certain third-party states in various specific aspects of financial services to be recognized as equivalent to the EU regime, and therefore allowing those companies to trade into the EU space on the basis of that mutual recognition. But there are a number of issues with that. One is that the equivalency regime doesn't cover the waterfront for financial services. That's the first thing. The other thing is it's in the gift of the EU. And so it's not something that one can request as of right. The UK actually sought to include some assumptions within the trade agreement that it's proposing with the EU that would facilitate equivalence, and that seems to have fallen off the table. The other thing is the EU can take it away, so it's not 100% stable. And finally, some commentators argue that the conditions for the granting of equivalency are not entirely transparent or don't entirely depend on issues such as the stability of the market, but rather there can be some flavor of protectionism in it. So the general position or thought is that equivalency does not provide the same level of protection and access that UK financial services providers had as members of the single market who could passport anywhere. And so that's an issue that's going to face not only UK businesses, but also third parties who are seeking to trade into the EU from the UK.
Thanks for that. So I'm going to take you away from Brexit now and talk more generally through a financial services lens, though, of course. What other efforts have been undertaken to facilitate specifically international trade in financial services?
Well, as I was saying towards the beginning, there's been a recognition in international trade generally that beyond obvious barriers like tariffs, or in the context of international services, things that say, you need to be Swedish in order to do this in our country, that kind of nationality-based discrimination, that the dissimilarity of regulatory regimes can be one of the greatest barriers to international trade in services. And so what we've seen, and this is an area, Matt, I'm sure you'd know even more than I would, is sustained attempts over the last decades to achieve a greater degree of international harmonization. And I had a list here to remind myself, but you have bodies like the Basel Committee on Banking Supervision, the International Organization of Insurance Supervision, and the International Organization of Securities Commissions, which in turn collaborate with the Financial Stability Board, which was set up further to a G20 meeting in about 2008. So, things coming out of the financial services crisis of 2007, 2008. And those are an important and really key alternative focus and forum for the breaking down of barriers to international financial services trade through an attempt at harmonization. There can be other agreements that arise out of that, mutual recognition agreements, for example, between different jurisdictions. And so for financial services providers, paying attention to that process in terms of international trade is also key.
Yeah, and I'll just echo what you just said, having been involved in deliberations with some of those international bodies while I was serving in the U.S. government. They play a critically important role in terms of bringing people together and establishing a baseline before the jurisdictions then move forward.
Yeah.
So I just want to move forward a little bit, and I think that for this next question, our practices are probably pretty similar, although very different arenas. But could you speak just a little bit about the utility of financial services institutions being engaged in trade policy issues?
Well, I do think it's very important. What we've seen, as I've suggested over the years, is that international trade negotiations have tended to go deeper and deeper into how economies function and the kind of regulatory framework of those economies. And there can be certain harmonization efforts that occur through free trade agreement negotiations, or indeed, as we were just saying, through these alternative agreement discussions that are happening at the institutional level, the various Basel Committee and so on. And so in my experience, it's very important for players within a financial services space to know what's going on in terms of these discussions. I mean, Matt, you and I have been government officials. You need input from industry to help guide and say, what are important issues? What are the barriers that you're facing? Is this kind of rule that we're proposing to harmonize, is this going to work? What are some of the issues that this is going to give rise to? And it's a complex kind of scheme because there's work going on at the WTO, there's work going on within these various committees, and there can be bilateral work, there can be multilateral work under things like the Trans-Pacific Partnership, to give one recent example. So it is very important for active players in international financial services to be engaged, to be informed, to know where the discussions are taking place, and to seek to input into them. Because ultimately all of this work, the work of those who are engaged in international trade, is to help make the international economy work better. And who better to provide input into that process but the financial services suppliers themselves.
I think that's a perfect place for us to draw this conversation to an end. Thank you for closing on such an important point.
Well, thanks, Matt. And I'm happy to be continuing to be engaged in this area. I think it's fascinating. And just as one final point, I think the fear that there is of international trade, of this is a question of race to the bottom or of kind of breaking down of standards, I think quite to the contrary. It's often an effort to achieve standards that are mutually beneficial, but that reflect a range of very strong and important societal goals relating to the environment, relating to sustainable development, relating to strong labor markets, and so on. And so I think that engagement in this process for all members of civil society is important to achieve the policy goals that will make the economy work in the way that we want it to work.
Thanks. And Christophe, thanks for joining me. I really appreciate it.
Thank you, Matt.
So that does it for another episode of Steptoe's Financial Services University, where we dove into the world of international trade and investment agreements. You can watch more of our videos and get more information about our practice at steptoe.com. Thanks for watching. We'll see you next time.